Hello, my name is Magdalena Slominski, and today I will be discussing the topic which was posted in week 7. In the following presentation, I will be discussing the relation between the Canadian Constitution and the health laws that pertain to abortions. I'll begin by discussing what abortions are, the different health laws against abortions, and the Constitution, as well as the more gentler case. The Canadian Federation for Sexual Health defines abortion as the ending of a pregnancy. A surgical abortion procedure involves an ultrasound to confirm the pregnancy and the weeks of pregnancy. The cervix is then examined using a speculum, which is then numbed with an injection of local anesthetics. A physician will then gradually dilate the cervix and will proceed with the insertion of a hollow tube attached to an aspirator machine, which enters into the uterus and removes its contents. Medical abortion differs from a surgical abortion, as instead of a surgery, medications such as methotrexate and misoprostol are used. This form of medication, which can come in the form of a pill, is oftentimes confused with the emergency contraceptive pill, which are used to prevent a pregnancy if you have had unprotected sex. The emergency contraceptive pill will by no means have an effect if you are already pregnant. In the Abortion Rights Coalition of Canada, we see that Canada is the only democratic country in the world with no laws restricting abortion since 1988. As stated in the Constitution, abortion is a subject that is quite troubling for the Canadian society for some time now. This topic involves many different viewpoints about individual rights, societal responsibilities, moral norms, and the role of women in society. In 1988, the Criminal Code standing abortion procedures were taken down by the Supreme Court of Canada, known as the more gentler decision, where a new abortion bill, Bill C-43, was introduced in Parliament late 1989. The reasoning behind this was that it was violating women's constitutional rights under Canada's Charter of Rights and Freedoms, particularly the law discriminating against disadvantaged women, such as poor, young, and rural women, many of whom were unable to access abortion services. They also found that the procedure increased the risks to the health of the pregnant women, both physically and psychologically, violating the women's security of the person. At this time, Judge Bertha Wilson had stated that abortion is a charter right based on women's right to life, personal liberty, and freedom of conscience. Following the more gentler decision, the Canadian government tried to pass a law in 1990 that would put doctors in jail for 2 years for performing abortions. Yet this law had failed due to the massive protests from women across the country. Now I will be discussing the more gentler case. In 1983, Dr. Henry Morgentler, Leslie Frank Smoling, and Robert Scott were charged with unlawfully procuring miscarriages in their personal Toronto clinics in violation of Section 251 of the Criminal Code. Section 251 of the Criminal Code allows for abortions to be performed only if done so at a hospital with proper certification of approval from the hospital's Therapeutic Abortion Committee, consisting of at least 3 doctors. The court's decision came down to the constitutionality of Section 251, specifically whether it violated Section 7 of the Charter of Rights and Freedoms. In the end, the majority agreed that Section 251 of Criminal Code invaded a woman's right to security of the person, and the process by which a woman was deprived of that right was not in accord of the fundamental justice, which would be Section 7 of the Charter, being a constitutional provision that protects the individual's autonomy and personal legal rights from the actions of the Government of Canada's right to life, liberty, and security of the person. The majority also agreed upon the state's interest in protecting the fetus if legitimate, but the right to security of the person of a pregnant woman was infringed more than was required to achieve the objective of protecting the fetus, which was Section 1. The court ruled 5-2 that the law violated Section 7 and could not be saved under Section 1. As stated earlier, BC 43 was then introduced, stated that a person inducing an abortion was guilty of an indictable offense and liable to imprisonment for a term not exceeding 2 years, unless it was done by or under the direction of a medical practitioner who is of the opinion that if the abortions were not induced, the health or life of the female person would likely be threatened. The bill was adopted by the House of Commons, but defeated in the Senate following a tie vote in January 1991. Currently, there is no legal restrictions in place in Canada. Abortion services begin to be managed under the Canadian Health Act as a medically required service. The federal law guarantees fully funded health care to Canadians. Under the Act, abortions must be provided in the same way as any other necessary health service. It must be performed by a doctor, it must be accessible to all Canadians in all areas of Canada, and it must be funded. Laws against abortions do nothing to stop or reduce them. A recent study done by the World Health Organization found that overall abortion rates in the world are similar, regardless if the abortions are legal or not in that country. Restrictive abortion laws are not associated with low abortion rates. So for my discussion questions, do you believe that women's rights to abortions should be protected under constitutional religious freedom guarantees, including freedom of conscience? And do you believe that all countries should abolish any laws against abortions whatsoever in the means of abortion as a moral and positive choice, liberating women and saving them? Thank you.